let's get started. And today I'm as a member of the Silicon Valley Arbitration and Mediation Young Practitioner Steering Committee. And I'm very happy to have, on one hand, Juan Mazariegos, the Secretary of the Instituto de Resolución de Controversias of Blockchain and Tecnología, which in English is basically the arbitral institution for blockchain and technology disputes. And on the other hand, I have Adriana Unson, that she is head of the Americas of the Singapore International Arbitration Center. So thank you both for joining us today. I'm going to give a quick bio of each one of you, so don't get too shy. I'm just going to go through the relevant findings. And for those that don't know me, I am Mauricio Duarte. I am the Chief Operating Officer with A2J Tech and also an off-council partner with Legal Plus. So I'm going to start with Juan. Juan Mazariegos Puertas is the Secretary of the Operations Committee of the Institución de Resolución de Conflictos de Blockchain y Tecnología, IBT. That is the first arbitral institution in Latin America, which is solely focused on resolving disputes concerning technology-related issues in the region. Under his administration, IBT has expanded to over 14 different jurisdictions in the continent and has advised governmental and non-governmental agencies concerning regulatory and policy issues that the fintech industry may suffer from lack of clear regulation. And thank you, Juan, again, for joining us today. And on the other hand, we have Adriana Unson, that she's head of Americas of the Singapore International Arbitration Center. Adriana oversees SIAC's activity in North and South America. She has broad experience as an arbitrator, practitioner, and having served as an arbitrator, international arbitration lawyer, and counsel in the SIAC Secretariat. Adriana is also a fellow of the Singapore Institute of Arbitrators. She's an active member at Young SIAC Committee and the Chartered Institute of Arbitrators Young Members Group. So thank you as well, Adriana, for joining us. I know it's 10 p.m. for you in Singapore on a Friday, but so I'm very grateful that you were able to join us today. So we're gonna get started. Just to explain the dynamic, it's gonna be a Q&A session. I'm gonna pose some questions in which both Adriana and Juan are gonna be able to answer them. Some of them are framed for them specifically, depending on their experience and some of their background. So before getting into the more detailed and granular questions, I want to pose a general question to both of you to start giving us some of the context that I want to discuss. And the main topics that I want to address today is usually when we see the tech industry and the tech sector as a whole, we see that not everyone, let's say, submits their disputes via arbitration. There's still work to be done, I would say, in both ends, not only in the tech industry, but also in the arbitration industry, to have a perfect match in order to arbitration become a better forum for resolving disputes. I still, even on the practice that I do, I still see plenty of startups and tech companies that decide to submit their disputes on local jurisdictions, which again are different incentives, different reasons why. But before starting, Adriana and Juan, how would you assess the overall state of arbitration in tech disputes and the tech industry? So let's jump it up with Adriana, and then Juan, we can go with you.
Thanks, Mauricio. Hi, good morning to all of you with us today. And of course, thank you to the Silicon Valley Arbitration and Mediation Center, young professionals for making this happen. So to answer your question, Mauricio, I think arbitration in the tech industry is growing. For instance, conversations such as this and the increasing amount of discussions, webinars, events created around this topic is already indicative. We also see the rise in number of tech-related arbitration disputes brought before arbitration centers. So for instance, at SIC, our tech caseload has grown dramatically, both in terms of filing frequency and claim amounts. The type of cases that we have handled include license agreements, joint ventures, and sales agreements. And we are also seeing an increased number of cases involving NFTs, cryptocurrencies, such as disputes arising from token sales agreements, trading platform vulnerability issues. We see software programming issues, amongst others. We also administer gaming and blockchain disputes as applied in fintech and e-commerce. And we see these cases coming not only from Singapore, but also from Southeast Asia, the Americas, and Europe. I think there really seems to be a cultural shift with the tech sector, which is perhaps beginning to realize the benefits of arbitration, such as neutrality, which avoids the risk of foreign court bias, specialized expertise of decision makers, which is important, especially since tech can be a highly specialized field, and each new advance in technology creates greater demand for sophisticated decision making. Arbitration is also known to be more, efficient with flexible procedures that parties can curate. And at SIC, what we're seeing is that the clauses involving tech disputes usually indicate the preference for expedited procedure, which allows for cases to be dealt with within 6 months. Also, one feature of arbitration for tech disputes is privacy to protect confidential business and information and trade secrets. And considering that most tech companies engage in cross-border transactions, arbitration's international enforcement features is also a plus. Now, we are also seeing new forms of dispute resolution, such as decentralized justice and blockchain arbitration, which I first learned from Mauricio a year ago when we sat on a panel together. And what this shows really is both the growing number of tech-related arbitrations and also the increasing use of tech in arbitration. Thank you.
Thank you, Adriana. Juan, do you want to add or frame other additional items based on Adriana's input?
Sure. Thank you very much, Mauricio. And also, thank you for the invitation for this panel. I do appreciate being here with Adriana and you as well, Mauricio. So going into the question itself, I will have to speak a little bit about the Latin American context, because after all, this is exactly where the IBT actually develops the industry. So I will have to focus on this specifically. And here in Latin America, it is still very common, as you were mentioning before, Mauricio, to see all types of contracts with submission clauses to national courts. And the tech industry, unfortunately, is not an exception to this rule. In my experience, I would say that about half of the dispute resolution clauses of the tech industry still refer to national courts and national jurisdictions. This is especially the case with Argentinian and Colombian companies, which both typically tend to go to national courts to solve their dispute. This, of course, can be a little bit of a problem when you consider the general state of Latin American courts and Latin American jurisdictions when it comes to solving disputes. Contrary to popular belief, the issue with Latin American courts is typically not an issue of corruption, but of judicial delay. In fact, according to the Rule of Law Index, out of the 10 slowest court systems in the world, 3 of them are in Latin America. The other half of the dispute resolution clauses are composed of arbitration agreements with institutions outside of Latin America, such as, for example, the ICC, JAMS, the American Arbitration Association, the London Court of International Arbitration, or even ad hoc arbitration agreements. The reason as to why this happens is due to the standard use of industry papers or industry contracts, which already have these types of clauses and just never shifted from the contract themselves. In general, I would say that the tech industry is slowly coming around to the use of arbitration because at the end of the day, well, that's already things that we're aware of since we're arbitration practitioners. But first, it typically brings a much more expedited procedure than national courts. And also you have the advantage of talking to someone who is actually aware of the context of the industry.
Thank you. Thank you, Juan. And now going back to Adriana, because I would say for different reasons, I have been involved in the Asian markets, in Malaysia and some other Asian markets on their tech industry that is growing exponentially. But and I have also seen that there are still some topics on the Asian markets that are still subject, or there are questions about arbitrability of those topics. So my question that I pose to you is, in your opinion, what are some of the issues in the tech industry and tech disputes that don't lend themselves to arbitrations, or there are still questions around them if they should be subject to arbitration because of arbitrability concerns, enforcement, and public policies? Adriana.
Thanks, Mauricio. So, yeah, you're right. Having said all the benefits of arbitration earlier, that comes with a caveat that not, every dispute can be arbitrated because of reasons of arbitrability. And of course, the first thing that comes to mind would be IP disputes. So not all IP disputes are arbitrable, and not every jurisdiction would allow IP disputes to go into arbitration. So that's something that parties have to watch out for when they're writing in, arbitration clauses in their contracts. For us at Singapore, we've made revisions to our laws recently to make it clear that IP disputes are arbitrable, but in some jurisdictions, there would be a carve out in this space. There would also be certain issues that do not arise from a contract, and arbitration being a creature of contract would require a contract. Well, so for instance, we have IP infringement, regulatory issues, competition, or antitrust matters, cybersecurity and data breaches. So these may not lend itself well to arbitration. And as we are also seeing more complex disputes in this sector, there may also be certain issues on the perceived limits of arbitration rules. So not only is it about arbitrability, but whether arbitration as a dispute resolution mechanism can handle cases such as class action style of dispute, and whether the application of joinder and consolidation mechanism in arbitration is enough or able to accommodate class action types of disputes. This remains to be seen, but arbitral institutions have been known to find ways to consistently enhance their rules to meet the changing nature of disputes brought before it. So in terms of, you mentioned about enforcement, the other thing I can think about would be disputes relating to new technologies such as cryptocurrency and NFTs, blockchain. So certain jurisdictions do not even recognize the legality of these. So for instance, I think China, Qatar would be some of them. So if you're arbitrating disputes involving cryptocurrency, parties should also be checking the place of enforcement, whether this would be seen as a public policy issue that would prevent its enforcement.
Thank you, Adriana. And yeah, I think one of the things that I have also seen is on many tech companies, data protection issues. Sometimes on arbitration, again, you don't have on your privacy policies a submission to arbitration. Usually you have that on your terms of service, your terms and conditions. So if there's a breach on personal data or data protection, what is the best avenue? So stuff like that, there's still many questions that I also think it's also going to come with more experience from the tech companies and tech startups. Start noticing that those issues could also be potentially subject to arbitration, depending on jurisdiction and if it's not against public policy. So now moving on to you, Juan, I want to ask a question that is focused on Latin America specifically, and considering that Latin America is still an emerging market in the technology industry. There, let's say, plenty of developments. There's a few unicorns here and there in the region. How do you attract those startups and growing technology companies to solve their disputes in arbitration, since there is not a big culture or arbitral culture in the region? Juan.
Thank you, Mauricio. So typically when I'm having these types of conversations with people who are not arbitration practitioners, I tend to show them the rule of law index, which, if you don't mind, I will share with all of you. And please do indicate to me when you can actually see it. Okay, can you see it?
Yep.
Okay, so as you can actually see from the rule of law index, which was made by the World Justice Project, here you can see some really interesting statistics concerning different countries all around the world. Now, here specifically, if we go to Latin America and we actually see the civil justice index itself, we will see that many of the countries in the bottom of it are actually Latin American countries, such as, well, for example, my country, Guatemala. Unfortunately, we're not the exception to it. And that actually brings a very interesting point with people that I'm typically having those conversations with, because mostly they are people who do not have any experience in this specific field of law. And that is pretty much making a comparison between national courts and arbitration proceedings themselves, which to us might sound a little bit basic. It's, after all, what we learn in law school when we're actually looking into what arbitration is itself. Yet, when you're speaking to different groups, and here I would actually say that there are four main groups you should be talking to when you're trying to promote arbitration in Latin America. First, well, and more specifically in the tech industry sector. First, in-house lawyers of tech industries. After all, they are the ones who will be putting the arbitration clauses inside of their contract. So actually explaining all of the benefits of arbitration to them is very important. Second, it would be investment funds. You actually mentioned, Mauricio, that there are several unicorns here in Latin America right now. And according to Forbes, most of those unicorns in Latin America are actually from the fintech industry. So when you actually go to the CEOs of the different investment funds and you explain to them the difference or how hard can it actually be to bring a suit in a Latin American court, they're much more favorable to actually incorporating alternative dispute resolution mechanisms, which after all is what we're trying to do here. The third would be to the CEOs of the tech companies themselves. This is a very similar conversation than the one that you have with the CEO of investment funds. After all, you're trying to explain to them what the actual benefits of arbitration are. And something that I have found very interesting in Latin America is the use of consumer arbitration, meaning when you're actually trying to put providers against consumers in arbitration. There are several jurisdictions in Latin America which do not actually allow for these proceedings. But fortunately, Guatemala, which is the country that I'm based on, is one of the jurisdictions that allows you to actually do that. So one of the things that we expect at IBT to happen in the following years is to see an increased demand on arbitration concerning NFTs and consumer rights, which will be able to be arbitrated through our specific programs, of course, but more specifically in several jurisdictions in Latin America. And that would be my comments on that point, Mauricio.
Thank you, Juan. And now let's say that we have framed some of the challenges, let's say, and the circumstances or problems around the industry or still hesitations. I also always think that in order to have a successful ever-growing industry, or let's say mechanism, in this case, we're talking about how arbitration can become more attractive for technology companies. I usually think also arbitration, on the arbitration side, there has work to be done. So from the question that I posed to both of you, and we can start with Adriana again, is what are some of the tangible steps that arbitration centers can take to become more appealing or attractive to the tech industry and tech disputes? Again, is that becoming virtual? Is that having more shorter arbitration processes? Again, Adriana, any insight would be valuable for us.
Thanks, Mauricio. So I think, for one, having expert decision makers or arbitrators is one of the features of arbitration, that really makes it suitable for tech disputes. That's why for us at SIC, we have created a panel specifically for tech and IP arbitrators. We are also actively searching for arbitrators' experience in various kinds of tech disputes, as we are now seeing arbitration clauses with specific sector experience requirements. So, such as a clause that specifically states that the arbitrator should have a cryptocurrency or patent backgrounds. And just to use this opportunity to announce, we actually entered into a partnership with FedArb. It is a Palo Alto-based dispute resolution center to create a joint model clause where parties could avail of SIC's case administration services in Palo Alto and choose from SIC and FedArb's pool of tech and IP panel of arbitrators. So what we have done in this is that we sort of give our users a wider pool of arbitrators to choose from and to bring SIC to Silicon Valley. Now, arbitration or arbitral institutions should also innovate with new rules and procedures to allow better handling of tech-related disputes. And to address the issue of cost and efficiency, SIC has developed rules and procedures for emergency arbitrators, early dismissal of claims and defenses, expedited proceedings, amongst others. And making sure that disputes can be resolved quickly is not only helpful in terms of attracting these tech companies because of the savings in time and cost, but I think it's also helpful, particularly in the types of tech disputes that we're seeing, such as cryptocurrency disputes, where dramatic shifts in valuations could take place. So an early resolution of those cases, the availability of early dismissal and claims procedures would somehow help in that regard. Now, aside from the existing rules that most centers have, perhaps creating more specialized rules would attract tech cases. So for instance, there is the digital dispute resolution rules by the UK jurisdiction task force, which I understand allows for dispute resolution in a very, very short period and allows arbitrators to enforce decisions directly on chain using a private key. And the rules also provides option to anonymize the party. So that's something we're also looking at. Now, centers should also, if not already, improve cybersecurity and confidentiality to minimize the risk of hacking and leakage of sensitive data, and should also, also utilize the power of tech itself to lower the cost of arbitration. Now, arbitral centers are known thought leaders, and I think providing continued education and training in tech-related dispute resolution for both arbitrators and counsel can also serve in promoting arbitration. But Mauricio, at the end of the day, it's an ongoing conversation. Institutions like us are always looking for feedback. So the question you post to me is the same question that we have to the tech community. And that is, what would make arbitration more appealing to them?
Oh, thank you for that, Adriana. And just as a caveat before we go with Juan's insight, I have seen that some of the, besides, let's say, taking tangible steps such as changing the rules or changing the processes, sometimes it's even as simple as how do you market yourselves? And for instance, startups and tech companies know all about marketing and SEO and everything like that. But one of the things that I'm not working in arbitration centers anymore. My contact with arbitration is completely different than it was used to be before. But when I asked them, what would it take to be amicable to have arbitrations, is let's go to their website, let's go to their social media. Do they have anything like that? Because now for many, even CEOs or COOs, it's how do they market themselves? So it's small things that I think it comes with also that challenge of meeting new generations where they're at. So it also gonna come with a new mind perspective of saying, now we have to market ourselves. Initially, let's say, because of the prestige of our arbitral institutions, we expected tech companies or the tech startups to come to us. Now it seems like things are shifting. So it's also about reading those dynamics, but I appreciate your insight, Adriana. So now, Juan, moving on.
Wait,
to you.
Mauricio, sorry,
Yep.
sorry, Juan, before moving to that, I just want to plug and say, well, it's good thing that SIC just launched its new website. And then we have an SIC America's Instagram page and Twitter account, so please feel free to follow up.
There you are, taking those steps. So now moving on to you, Juan, the same question that I posed to Adriana. What are some of the tangible steps do you think that arbitration centers can take to become more appealing or have more incentives for the tech industry or tech companies to solve their disputes via arbitration?
Thank you, Mauricio. Well, actually, I think I'll start with this last topic that both of you guys were answering right now. And I do agree with you that using social media in order to be able to portray yourself as a more sophisticated type of arbitration institution is really helpful. For example, I would say that most of the growth that the IBT has gotten through like spoken word would be through LinkedIn. We have used a lot of LinkedIn in order to promote the services of the IBT Center. Partnerships and alliances are always polished there, and that is always a very important step to take, because that actually it kind of makes some sort of sense of community with different law practitioners and different arbitration practitioners in general who are actually in this field of law. So definitely the use of social media is a very key component to all of this. Second, and I will have to completely agree with Adriana on this point, having specialized arbitrators in the industry is one of the most important decisions that you can actually take. Because, and I was actually having this conversation with the CEO of a company which actually made a crypto wallet here in Latin America. And we were discussing, and he asked me, why would I go to arbitration if the person who is going to know as an arbitrator of the dispute will probably know as much as a national judge concerning the substance of the dispute? And that is why it is very important to have people in your arbitrators lists who are actually aware of these different new technologies, such as, for example, fintech, such as blockchain. That is why on the IBT Center, one of our 3 lists of arbitrators actually just concerns people who are already practiced in the fintech and crypto industries. We believe that that is one of the things that truly adds value to the arbitration institution itself. The second thing, well, the third thing that I would say that actually helps a lot with gaining the trust of the tech industry is trying to make use of the new technologies in arbitration proceedings. For example, we in the IBT centers, for the awards themselves, we actually certify them in using blockchain technology. That is not only something like cool to say, because after all, blockchain is part of the name of the institution itself, that actually has a practical ramification. Under Article 4 of the New York Convention, you actually require the certification of the award before the award can actually be enforceable. But it is never actually established how the certification might come around. So what we figured with that is through the use of blockchain technology, and that was actually the suggestion of one of our arbitrators in Venezuela, we could certify our awards with a much lower cost than it would have to go through a public notary. For example, with around $50, you can certify the award, and that could be used in national courts in order to make it enforceable. So actually making use of these new technologies not only shows you that you're aware of the changes that are going on in the industry, but you're actually using the services of the people that one day you might know their dispute. So it's both like a win-win situation. Also, one of the things that is very important is to make partnerships and alliances with different institutions which also have the same objectives as you. Of course, on the one hand, we're trying to promote arbitration, but we're also trying to promote the responsible use of technology. For example, we're not looking for in Latin America, as markets already are, we're not looking for example, scams that have happened in the EU or in the USA concerning NFTs or the pump and dump, which is commonly known in the crypto industry. We're not looking forward to that. And that's also part of having alliances and partnerships, not just with private entities, but also with state entities. For example, here in Guatemala, I have had the chance to meet up with the Superintendencia de Bancos, which is one of the regulatory bodies in the Guatemalan system that will be the ones supervising the use of cryptocurrencies in the country. So that is one of the many examples that arbitration centers should have when they're actually trying to gain the trust of the tech industry.
Thank you, Juan, for that. And it's interesting that you are certifying via blockchain. I still remember that when I was in the arbitration industry a few years ago now, I think I wrote a arbitration blog about using blockchain technology to certify arbitral awards. So it's good to know that now someone is doing that. I think that blog post was in 2017. So has been a long time coming. So it's fun to hear that. And now I want to move on to the next question. And this is, again, we have talked about what arbitration centers can do, what is the current state of the tech industry, the tech disputes. But at the same time, I also think that there are sometimes things associated with the tech industry that either arbitration centers don't want to, let's say, deal with, or are concerns on their perspective. For instance, again, I'm not on a directive board or an executive position in an arbitration center, but for instance, one of the concerns I would have, for instance, are in those tech industries that are not heavily regulated, or we don't have any legal context or background to solve a dispute, rather than, let's say, we can use other types of mechanisms or integrate rules and so on. But for instance, cryptocurrency, that is still one of the industries that rarely is regulated around the world. Now we are seeing the trend that more regulations are going to come. We're going to have more clarity on what should be the approach on, for instance, if it's a exchange or if it's a wallet, what is the approach? But the question that I pose to you as directives of arbitration institutions is, what are some of the struggles, concerns, or even limitations that come with the tech industry and tech disputes? I don't think everything is shiny and let's say rainbows, but there could be some let's say practical concerns or struggles that you think, you know what, since this is the current status of the market and the regulations on this specific tech or industry or tech dispute, I think we're, let's say, it's not necessarily something convenient for us. Let's certainly the other way around, and let's start with you, Juan, and then I'll pass the word to Adrian.
Sure, thank you very much, Mauricio. So I would say that the struggles are twofold. First, and this is a critique which has always been made to arbitration, and arbitration proceedings are significantly more costly than just going through a national court. And even though we would all like arbitration proceedings to be made between multi-million-dollar tech industry giants, most of the time, what you will see is startups like fintech startups or crypto startups or similar types of companies who are the ones actually having the problems with the other parties. So that being the case, one of the things that tends to scare the tech industry away from arbitration itself would be the costs that are associated with arbitration. That is why one of the things that Adriana was mentioning before, meaning the expedited process of the arbitration proceedings, is of key importance, because typically having an expedited procedure also means having lower costs for the parties. And of course, saying you will have a lower cost to solve your dispute to a startup that typically requires every dollar to function, that kind of tends to win them over in that situation. And also, there was something that you brought up, Mauricio, which I believe is very important, and that is, how can you actually convince the tech industry and the regulators to work alongside each other when there is so much unknown concerning legislations on the tech industry? And that is why, and I mentioned this point before, it is very important to actually be the bridge, and we as arbitration centers can actually fulfill that job, to be the bridge between the regulator and the tech industry itself, because we're actually trying to put forward, like, using the different technologies that the technology sector is bringing with them, and we're trying to use them in a more general sense, which can be palatable to the regulator. So we can typically serve as this bridge between both of those parties, and that is something that could help the adoption of arbitration in the tech industry as a whole. I believe that I ramble off a little bit to another topic there, but I thought it was important.
Oh, thank you for that, Juan. And now, Adriana, from your perspective, again, what are some concerns, struggles, even limitations that you see or you have discussed at SIAC about the tech industry or the tech disputes?
Thanks, Mauricio. Well, to add to Juan's points, actually, I agree with what he just said. And what we're seeing, and the more I go around and talk to people, I think, one thing that may be an issue would be perhaps the general lack of understanding or experience in the use of arbitration in the tech industry. And I think Mauricio made reference to this earlier. I think, after all, if you look at it, it's only recently or in the past decade that we are seeing the increasing use of arbitration in this sector. So maybe there is still some comfort for tech companies to go to court, and that's one struggle that maybe arbitration has in terms of being appealable to the tech industry. And as Juan mentioned, this issue on cost and the perception that only high value cases should go to arbitration. And this is something really most arbitral centers have been trying to address through the various cost and time saving features in their rules and availability of alternative platforms such as the dispute resolutions, which cater specifically to low value disputes. So online dispute resolutions, even dispute resolution methods on the blockchain are offered to low value disputes. There may also be concerns regarding the lack of appellate mechanism. I think this is addressed in certain jurisdictions. So for instance, in Singapore, there is a possibility to opt into the Domestic Arbitration Act and have an appeal on a point of law, and some tech companies like this. We are also seeing, while one of the benefits of arbitration is really being able to provide an expert arbitrator in specific fields of tech cases, there are also this feedback that there is a limited amount of arbitrators that are expert enough to handle specific type of tech disputes, especially because it keeps becoming more complex through the years. And again, like what I said earlier, there are issues on enforcement based on public policy ground. For example, like what I said earlier, mainland China, Russia, Qatar have, from what I know, banned crypto assets, or at least heavily regulate those there. So if a crypto arbitration, again, is seated in such a jurisdiction, or an enforcement of award is sought there, then national courts may rule that crypto disputes are not arbitrable and deny enforcement. So those are some of the things that I'm seeing in terms of, struggle of arbitration in tech disputes.
Great, thank you, Adriana. And I know we are coming, let's say, on time in a few minutes. So again, this is just, if anyone in the audience wants to also ask a question, please use the Q&A function. We have some final questions to start wrapping up. But if you want something to ask the panelists or for me to address with them, please feel free to use the Q&A. And going back to you, Adriana, one of the things that I have, and say, obviously, we are all aware of what happened during COVID-19. Some arbitration centers needed to become more digital savvy, start deploying, let's say, a digital infrastructure in order to have virtual hearings. And let's say we know what happened after that. Good practices of virtual hearings, handbooks from the ICC, the IBA started to, let's say, explore more of the digital components of arbitrations. But my question to you is, how can arbitration centers either start or improve to be more digital? And let's say after COVID-19, some of the parties to arbitration really liked some of the benefits that came with it. For instance, remote hearings, lowering the cost of arbitration. So I know it's a discussion, because also having a physical location and a physical process also has its benefits. So I'm wondering, how do you assess that pro-con, weighing the benefits of a digital arbitration center and trying to promote other tools and uses of technology within SEAC?
Sure, thanks, Mauricio. So to answer first your question on how centers can be more digital, I think most arbitration centers have embraced technology where it became especially necessary during the pandemic. So from the start of the case proceedings to its culmination in the award transmission, I think institutions have really taken the lead to encourage the use of tech to minimize disruptions. Now, based on my experience at SIC, for commencement of arbitrations, we have informed users to commence cases by email, including their applications for emergency arbitrators. And in terms of case management, we are currently working to enhance our existing digital infrastructure to allow for a fully electronic case management system that supports electronic case filing, payment, correspondence, document storage, and transmission of awards to, really enhance the experience of arbitration and potentially save on costs. So some of our processes are already automated, and it's really been helpful, and we're trying to fully automate more of our processes. We are also intending to make updates on our next set of rules to explicitly provide for and facilitate online correspondence. Now, in terms of hearings, parties are free to use commercially available platforms such as Zoom to conduct remote meetings and hearings. And, like what you said, some parties, at least for us, we see that they prefer virtual or hybrid hearings and conferences. And because of this, we have prepared a series of virtual hearing guides to help users navigate the use of communications technology and in remote hearings. And your question on whether it's better to have a physical hearing or a remote hearing, it really depends on case by case basis and the party's requirements. But the option of having it there is now, it's a really significant development because we're seeing less and less people traveling in person just to have, say, a procedural conference. And then there must be really some kind of justification for them to meet in person. But again, it really depends too on the tribunal, who has the autonomy to run the case as efficient as possible. We have, because of virtual hearings, we are able to have our case managers at SIC sitting in on these hearings. So they not only learn more about the proceedings, but they're also there to assist and answer any procedural questions that may arise. We also have a user-friendly searchable list of arbitrators available online and a digital library of our seminars, trainings, and workshops. And I think there is really a push for arbitration centers to be more digital in light of the pandemic, and of course, the realization that costs and time savings that these technologies bring.
Thank you, Adriana. And to start wrapping up, one final question that I have for you specifically, and then I have one final question for both. And it's, how do you envision, let's say, arbitration, or at least IBT or arbitration centers in general? Do you expect them to become fully digital in the near future? Do you still believe that it's going to be a hybrid model, such as Adriana was mentioning, that depends on a case-by-case basis? What is your outlook on, let's say, notions of having a complete digital arbitration center? Again, also considering that there are now new methods of solving disputes, as Adriana has mentioned, decentralized justice or blockchain-based projects that are looking at solving disputes. So I don't know if that has been a discussion at IPT, how you are approaching that, let's say, that the component of digital arbitration completely as you're an up-and-coming arbitration center in the region.
Thank you very much, Mauricio. So, okay, so on that topic, first, I should make the caveat, there will always be people who will actually prefer to have in-person hearings over virtual hearings. That is just a fact. That's typically people who have been practicing arbitration for many years. There's actually a very interesting court in the Supreme Court of Austria that actually talks about the examining of witnesses and experts and why it should be made in person instead of under a virtual venue. And that was actually a very interesting case when I first read it, because it kind of brings to the forefront the main issue, which is some people might never feel completely comfortable with the use of these new types of technologies in order to hold their hearings. That being said, I do believe that the future of arbitration itself should be digital. For example, in the IBT, if you read our institutional rules, we do have a bias in favor of using digital methods instead of having physical hearings. And that is for a very specific reason, because as Adriana was mentioning before, it tends to lower the costs of parties. And we're always trying to fight that opinion that arbitration must be costly, that arbitration is not for everyone. We actually believe in the democratization of arbitration itself. And one of the steps to actually reach that democratization is to have affordable arbitration proceedings. So that would be one. Second, in the IBT, you have probably both of you read the Seoul Protocol. I believe that SAC was involved in drafting some parts of it. I'm not quite sure on that point. But the thing is that you saw the Seoul Protocol. The Seoul Protocol has many references as to how to conduct correctly an online hearing. Well, on the IBT, we're taking it one step further, and we're making the first protocol concerning virtual hearings, but using like methods such as Oculus Quest, for example, because even though the technology itself might not there be yet, it will eventually be. And we're already preparing on the IBT Center in order to handle those types of disputes.
Thank you, Juan. And now, let's see, just because we are minutes away from wrapping up this discussion, which I have found very interesting, and I appreciate all your insight and comments, Adriana and Juan. But one last question that I pose to you all is, and I know I usually I'm very pragmatic overall, so I don't necessarily like the futuristic questions. But my question that I pose as a final for the two of you is, what is your outlook on arbitration's future in the tech industry and tech disputes? Do we envision a new, let's say, brave new world with new categories or types of arbitrations within arbitration centers? Do we see more expedited processes? Do we see a complete renovation of arbitration as it has existed so far? So what's the outlook of arbitration now that we are growing into new industries? Let's say, if I go to the Moore's law of exponential growth of computational power, I don't know if there's a Moore's law for arbitration, but I'm posing that question to you. So we can start with Adriana, and then we can wrap things up with Juan.
Thanks, Mauricio. I mean, I think it's really hard to crystal gaze with respect to tech, especially because the changes are so rapid. We didn't even realize a few years ago that this is all possible, that moving to tech is a necessity more than an option. I think there is an opportunity for arbitration to play an even more greater role in resolving technology disputes. And I mean, like we've discussed, we are already seeing this growing trends of disputes in the recent years through the increasing tech dispute caseloads, not only at SIC, but also of other arbitral institutions. What we might see in the future are more types of tech disputes that probably are unheard of at the moment, but then with the rapid changes in technology, we might come across these cases. And based on the survey of the landscape, we're really seeing tech disputes shifting to the arbitration for the reasons that I mentioned earlier. There's always going to be new technologies. There's also going to be more and more complex type of tech transactions and disputes, which will require decision makers who have tech expertise. And the increasingly international character of tech contracts would also make multi-jurisdiction enforcement more critical. There are, many technologies that have advanced dramatically in the past decades, and many that will advance beyond our expectations. I think the long-term future of technology, and in turn, technology arbitration remains unknown. But for now, I think arbitration will really play an increasingly crucial part in resolving these disputes.
Thank you, Adriana. Juan, to wrap us up.
Thank you, Mauricio. So I will go back to something that Adriana mentioned on the beginning of this presentation, and that was the importance of actually listening to the tech industry sector when it comes to the advancements of arbitration. We already, since we were taught from law school how arbitration actually works, we typically follow an specified model. And this model should be challenged by the tech industry as a whole in order to search for newer and newer, faster, and more innovative ways to actually resolve disputes between the parties. Also, I do believe that the future of the tech industry will have around 90% of their disputes being resolved through arbitration. We in IBT do have that belief, because after all, tech industry, and more specifically here in Latin America, typically comes from the presumption that there is some sort of thing that could be made better or could be made faster, or there is some way to improve it. And when people in the technology sector actually realize that arbitration proceedings are that to national courts, meaning a faster proceeding, a proceeding that actually has an expert that is listening to your case, they will come around eventually to arbitration as their preferred dispute resolution mechanisms. So that would be with my intervention, Mauricio, and I thank you very much for this panel.
Thank you, Juan and Adriana. And again, I don't see any questions in the QA, so I think there are no additional questions from the audience. And just to wrap us up, and I want to be respectful of everyone's time. First, I want to appreciate Juan's and Adriana's time for joining us. A valuable insight of what you're doing at your respective arbitral institutions, so thank you for that. But one thing to also wrap up as a final remark and from my end, I used to practice arbitration 5-6 years ago now. Now I'm on the tech side 100%. But I do think, based on my learnings on the tech side, is that the best solutions that come out of designing anything, designing a process, always involves grabbing other stakeholders or other perspectives that we never thought would be valuable. So for instance, even redesigning an arbitration process, that could sometimes mean having a business process improvement expert from Toyota teaching us how a process is actually constructed from scratch. Because again, we as lawyers have constructed processes which they work, but now I think we're also coming across that questioning, should we also think outside the box? We should involve designers, user research. We should have other components in order to rethink, again, not necessarily 100% of arbitration, but some other avenues to attract crypto disputes, what is going to be different from NFTs, and NFTs probably are going to be different from the fintech industry, and what is going to have with the health and tech side of things that has, or biological tech that is also an up and coming industry. So again, I just think that it's an interesting question and an interesting component on how the tech is also has learned to bring other different angles and perspectives to construct, again, deliver a product or a service. I think the same thing could happen to arbitration. But again, that's a good thing. I'm not practicing arbitration anymore. That's something that is going to rely on more prepared minds than myself. So with that, I want to wrap it up, and I want to thank everyone for joining us today. Again, Adriana from Singapore and Juan from Guatemala, the head of one of the secretary of IPT, and Adriana as the head of Americas in SIAC. I want to thank you both. I want to thank your respective organizations for helping us on this event. And at the same time, I want to thank the Silicon Valley Arbitration and Mediation Center, and also the Silicon Valley Arbitration and Mediation Young Practitioners Steering Committee for allowing us to have this discussion. So with that, just a final reminder, if you haven't done so, subscribe to the Silicon Valley Arbitration and Mediation YouTube channel. And this recording is going to be up probably the next week, and you can see, or you can share with some of your friends. So thank you, everyone. I hope you have a great day, and I'll see you in the next talk. So thank you again.
Thank you. Thanks, Mauricio.